back in 2021, Scotland passed this hate crime law that's called Hate Crime in Public Order Act of 2021. But it took effect, I believe, either yesterday or today, which is why it is making the news. And put simply, what it does is that it creates a new crime in the country of Scotland for, quote, stirring up hatred relating to age, disability, religion, sexual orientation, and of course, transgender and sexual identity. Okay? So it's now a hate crime to, quote, stir up hatred on the basis of those protected status groups, which is similar to what we have in the United States. We designate certain characteristics that people have as being part of protected classes. So this hate crime law in Scotland, again, taking effect today, carries a maximum penalty of a prison sentence of 7 years. This is according to the BBC. And those who are proponents of this law and who say, oh my gosh, all the naysayers, on Twitter and in the free speech verse are saying that this law is so draconian. Don't worry, there are protections. The protections that these individuals point to is that the law says that those who are, quote, stirring up hatred have to have been shown to behave in a way that, quote, a reasonable person would consider to be threatening or abusive. So it sounds fine, right? Like, oh, that's no problem. People who are hateful are going to be punished if it is deemed that their hate was reasonable. But here's the big caveat, as we know. We now live in a time in the West where words are completely hijacked of their meaning. Reasonable does not mean reasonable anymore. Just as racism doesn't mean racism anymore, or sexism, or patriarchy, or even the term offensive. Think about how much those words have been completely hijacked of their meaning. So those who are saying that there's that protection of the reasonable clause in this hate crime statute are totally missing the point. Here actually in the United States, in constitutional law, we have something called a rational basis standard. And it is one of the standards that the Supreme Court uses in order to decide whether government interference or a law that was passed should actually have been passed and that the government has a right to interfere. And literally, the definition of this rational basis test is that the court needs to be able to decide if the government's actions are, quote, rationally related to a legitimate government interest. And back when American society was pretty healthy and we used to agree on very basic things like the meaning of words, like the fact that there are only two genders, that speech is speech and violence is violence, speech is not violence. Back when we were a healthy society, one could have faith in the rational basis test here in the United States. But now, a lot of people can go, well, there is a rational basis for XYZ, whatever law I want. This is really the point of this, is that this is the effect of the hijacking and distortion of words. And as I have opined on Timeless many times, we saw this spread probably starting about a decade ago, just on a very interpersonal level, where people started to be more reckless with the term racist, with the term sexist, with the term offensive. And now we are really seeing the effects of it, because not only in our culture have these words taken on a different meaning and it has corroded our way of life, but now it is so common that it has literally leached itself into our legal system. And this is not about Scotland. I mean, it is about Scotland. It is not just about Scotland. This is happening right here in the United States. And I just want to rattle off a few examples of laws that have either been proposed or indeed have been passed that are based on these distortions of words, because it really is terrifying. If we start, for instance, with speech, with hate crime, there's actually a law that was passed in the House of Representatives in the state of Michigan that is very similar to this Scottish hate crime law. Just as a note, in Michigan, it was passed in the House. It has not yet become law in the state of Michigan. It needs to pass both chambers of Congress, and then it needs to be signed into law by the governor. But in the House, they passed this statute, which makes it a hate crime to, quote, maliciously and intentionally cause someone to, quote, feel terrorized, frightened, or threatened. And that, if it became law, would carry up to 5 years in prison and a $10,000 fine. Excuse me, I kept saying crime. But that is almost identical to the statute in Scotland. And to Sean's point, what are the boundaries of this? Look at, for instance, that wording in the Michigan bill, that it's a hate crime to cause someone to feel terrorized, frightened, or threatened. That flings wide open the door of subjectivity, because everybody's feelings are totally subjective. Someone could say something, and as we see in American society all the time, someone can say something totally innocuous, but it can make someone feel threatened and unsafe. And so this Michigan law is essentially trying to give people a lot of leeway to criminalize speech that they deem to be unacceptable. So that's example number one. This is happening all around the country in our own country. Example number one is Michigan. Example number two, in the state of Illinois, there's a bill that's being proposed, so it hasn't been passed into law yet, which would amend the Abused and Neglected Child Act in the state of Illinois to redefine an abused child as someone who, quote, has a parent who denies the child gender-affirming services. That is not what the word abuse means. Actually, this is where our society is so Orwellian, and I talk very often on this show about the inversions. Good is evil, up is down, left is right, men are women, women are men. I mean, denying your child gender-affirming services is not abuse. It's actually the opposite of abuse. It is protecting your child from making a life-altering decision that at that age they are not of the right, mature, fully developed mind to decide. But nevertheless, they're trying to amend this act to say that an abused child is one whose parent denies them these services. And that means that if it is passed into law in the state of Illinois, Child Protective Services would be able to take a child away from his or her parents if that child does not get the gender-affirming services because their parent tells them not to. Absolutely insane. That's example number two. I'm just going to rattle off a couple more. And trust me, I'm giving you the abbreviated version, but this is so important. People don't know about this, because, shocker, the mainstream media doesn't publish very many, if at all, articles about these things. So when people hear conservatives talk about the hijacking of language or about the distortion of our laws, they go, oh my gosh, those crazy right-wingers, they're such conspiracy theorists. It's not a conspiracy. It's happening right now. This is a law that was passed in the state of Washington. It redefines what the term compelling reason means. So this law in Washington state says that state shelters, which take kids who run away from home, these state shelters do not have to report to parents that their child ran away from home and is in that state shelter if that parent, you guessed it, denies that child gender-affirming care or gender-altering surgeries. This is a law in the state of Washington. And they list that denial of gender-affirming care as a, quote, compelling reason for the state to not notify the parent of the child's running away from home. That is not how we used to understand compelling reason as a term to mean. It is certainly a compelling reason if the child runs away from home to not notify the parent, if the parent is hitting them, if the parent is starving them, if the parent is torturing or neglecting them. That's what the compelling reason used to be understood as. Not this denying gender affirming care. It's terrifying. I'm going to go on. And again, I'm totally giving the abbreviated version, but I'm seeing in the chat that it's resonating. And really what we have to do is arm people with these facts because people don't know about this. Here's another one. Here in my home state of California, the state where we're filming this show, there was recently a law that was passed, you probably are aware of it, about gender-neutral toys, where a department store that has 500 or more employees is now mandated by the state to have a gender-neutral toy section instead of just a girls section and a boys section in the toy store. Guess what law they used to justify that government intervention? The Unruh Civil Rights Act. The Unruh Civil Rights Act was a law that was passed in 1959 in the state of California in order to, desegregate, public accommodations and businesses, and to give Black Americans equal rights to white Americans when Black Americans were being denied equal rights. The whole point of civil rights statutes and discrimination statutes is not so that a department store can have gender neutral toy section, but you see that what these individuals do is they try to push their political agenda and they leech onto these words like compelling, reasonable, abuse, discrimination, and they totally distort the meaning of those words in order to get what they want. So it's not just with the gender-neutral toy section in California. I'll give you another example. The California Department of Education says that it is, quote, discrimination for a school district to notify a child's parents of that child's gender transition. There's a school district in Sacramento which recently passed a law or a policy in that school district which said that teachers had to notify the parents if the child comes in and says that they're a different name or has different pronouns or is a different gender. And the California Department of Education threatened a lawsuit against that school district saying that it was discrimination for them to do so. I'm going to give one more example, and this one is a real zinger. I recently did a show on the various statues all around the country that have been torn down over the past really 3 to 5 years, but especially, of course, under President Biden's time in office. The Thomas Jefferson statue in New York City Hall was taken away. The iconic bronze statue, which was in front of the American Natural History Museum in New York, was hauled away. And then there was another one very recently, the Arlington Reconciliation Monument at Arlington National Cemetery was heisted out of there. And I showed all of these clips on the show, which are so chilling, of these cranes coming in and removing these parts of our history. And of course, there's this big debate about Confederate statues or statues which celebrate and glorify slave owners in the Confederacy. Putting that aside, there needs to be a objective and consensus among the American population building provision of how those statues ought to be dealt with, whether they should be removed, whether a plaque should be installed. I happen to be a proponent of the latter because I think it's actually very important for us to see our history and our ugly past. I want to keep Confederate statues up, not because I want to glorify the Confederacy, but because it is so it makes such an impression on a person to go about their everyday life and see that right here in the United States, Confederates marched here, etc. Okay, but you understand my point that we need to have some kind of consensus about these statues. Well, here's how they're dealing. They, meaning the government, is dealing with the tearing down of those statues. In 2021, there was an act that was passed called the National Defense Authorization Act. And you'd think, National Defense Authorization Act, what are they going to do? Increase spending for our defense, building more weapons, more infrastructure, getting more recruitment for more troops. That's what you would think the act would be about. Well, the act empowered what's called a naming commission. And it gives individuals in that naming commission the power to, quote, remove all names, symbols, displays, monuments, and paraphernalia that honor or commemorate the Confederate States of America. And they say that the reason for that naming commission to have that power is because it is in the interest of the U.S. national defense. So national defense doesn't anymore solely pertain to, as I said, weapons, soldier recruitment, military bases, etc. Defense has now moved into the category of deciding what statues stay up here in the United States. It's happening. It's not a conspiracy theory.